I rise today out of serious concern about the release of the 5 senior Taliban commanders detained at Guantanamo and the way in which the Obama administration accomplished it. These individuals that the Taliban successfully demanded the release of in exchange for Sergeant Bo Bergdahl were some of the most dangerous terrorists in our custody. Some had close operational ties to al-Qaeda. Others perpetrated horrifying war crimes. All were senior leaders in the Taliban, a group we remain at war with. These former detainees, the Taliban 5, are only subject to a 1-year international travel ban. It seems shockingly unrealistic to expect that they will not seek to undo everything our brave men and women in uniform have fought and died for in Afghanistan. Mr. President, however foolish, the prospect that we might release the most dangerous Guantanamo detainees has been a matter of national debate for some time. President Obama and his subordinates have long espoused a singular devotion to closing the detention facility at Guantanamo. Many of us in Congress have remained decidedly less sanguine about this long-time left-wing fantasy. We're wary of the dangers, inappropriateness, and oftentimes the impossibility of prosecuting battle-hardened terrorists in civilian court as if they were common criminals. We're frustrated by the procedural roadblocks to pursuing justice through military commissions. Above all else, we're alarmed by the more than 1 in 4 released detainees that have apparently rejoined the fight. And unlike the administration, we have long been disabused of the notion that our enemies and perennial critics would somehow fall in love with America if we simply closed Guantanamo. With these concerns in mind, we exercised our rightful legislative authority under the Constitution to prevent the transfer of any further detainees out of Guantanamo. Nevertheless, the Obama administration bitterly opposed any release restrictions. Facing incessant and intense pressure from the administration to repeal our ban, Congress acted on a bipartisan basis to reach a compromise that was extraordinarily generous to the administration's position. Under the new law in effect, Section 1035 of last year's National Defense Authorization Act, Congress must be notified 30 days before any detainee transfer. The notification must contain a detailed statement of the basis of transfer, an explanation of why the transfer is in the national security interests of the United States, and a description of the actions taken to mitigate the risks of detainees returning to the fight. Our subsequent funding legislation also banned the Obama administration from using any of the appropriated money to transfer detainees except in accordance with these agreed upon procedures. And despite this good faith effort on the part of Congress to find common ground with the President, he chose to simply disregard his statutory obligation to inform Congress of his highly controversial release of the Taliban 5. And while we should celebrate the return of any American from Taliban captivity, the President's actions carry very troubling consequences. Mr. President, when a lawmaker animatedly denounces the President's violation of a technical provision so wonky and seemingly unimportant as a statutory notification requirement, many Americans might understandably dismiss such a concern as a petty turf war if their eyes don't glaze over first. Though perhaps intuitive, such an impression couldn't be more wrong. First, notification requirements like this one have proven critically beneficial national security decision-making, particularly in the national security context. The most prominent example is our oversight of the intelligence community. For more than 30 years, prior congressional consultation has been a key foundation of ensuring effective policymaking on intelligence gathering activities and covert operations. On these incredibly sensitive and weighty issues, the executive branch is required to brief certain members of the legislative branch on all such proposed activities before they happen. The discussion of such highly classified information necessitates a strict observance of secrecy, which Congress has a long tradition of respecting. Discussions behind these closed doors provide the benefits of deliberation outside of the fishbowl of the ordinary policy process. In this setting, concern about national security and the wisdom of the contemplated action dominate. Politics takes a back seat. The administration can modify or cancel proposed actions without the costs that attach to public policy pronouncements. And by assuaging our concerns before execution, the administration gets the congressional buy-in that's so necessary when these sorts of difficult decisions are taken. Though the system certainly has its critics on all sides, I remain a passionate believer in its overall effectiveness. I should know, I served on the Senate Select Committee on Intelligence longer than any other Republican ever has. For years, I was intimately involved in this process and witnessed up close just how well it works to produce good policy. And in the context of national security, an area in which our nation regularly faces so many critical and difficult decisions, we need a well-functioning congressional oversight process to ensure our safety and security now more than ever. But even beyond improving an administration's national security decision-making, we should genuinely concern ourselves as a nation that formal restraints on power be observed by the coordinate branches of our government. Whether the administration agrees with the restrictions on its power to release Guantanamo detainees, those restrictions remain enshrined in a duly enacted federal statute. And the President remains obligated to take care that the laws be faithfully executed. To ignore the law and the President's constitutional obligation to see that the law is enforced may seem enticing in an instance of apparent pressing need. But our Constitution provides no such authority. Consider the wisdom of Justice Jackson in his seminal concurrence in the Steele seizure case. Quote, "The appeal that we declare the existence of inherent powers out of necessity to meet an emergency asks us to do what many think would be wise, although it is something the forefathers omitted. They knew what emergencies were. They made no express provision for exercise of extraordinary authority because of a crisis. I do not think we rightfully may so amend their work, and if we could, I am not convinced it would be wise to do so," unquote. Indeed, the central organizing principle of the federal government is the division of powers and authorities between the different branches. As a 21st century American, it is far too easy to treat the separation of powers as a cliche confined to the civics classroom rather than a meaningful conversation of our liberty or a meaningful cornerstone of our liberty. But we should recall Madison's warning in Federalist 47 that, quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny," unquote. To disregard these central precepts of constitutional government is to vitiate the barriers protecting us from arbitrary government action and to undermine the rule of law. We in the Congress should make no apology for zealously guarding the legal prerogatives of the body in which we serve. For as Madison also warned in Federalist 51, quote, "The great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachment of the others," unquote. Nevertheless, out of respect for a coordinate branch of government, the Obama administration's arguments excusing its action in releasing these 5 dangerous Taliban detainees merit thoughtful consideration and analysis. I've never been shy about defending the powers of the President when exercised lawfully, no matter how unpopular. Nevertheless, such a Such an examination of the Obama administration's explanations reveals not only the ridiculousness of its arguments, but also demonstrates deeply concerning attitudes and priorities that guided the administration's action. The Obama administration has advanced multiple distinct arguments about the legality of its move to release these senior Taliban leaders. Now, advancing multiple, sometimes contradictory arguments does not exactly instill confidence in the administration's commitment to its legal obligations. Some have been patently absurd, such as the suggestion from the White House press secretary that briefing members of Congress more than 2 years ago about the potential for the detainee exchange constituted sufficient compliance with the detailed statutory notification requirements for an actual decision to transfer. I want to examine the two more sophisticated rationales advanced by the administration because it's in the details of these arguments that my gravest concerns arise. First, I want to consider the National Security Council spokeswoman's written statement to the press asserting that, quote, Congress did not intend that the administration would be barred from taking the action it did in these circumstances, unquote. Now, trying to read Congress's mind when interpreting the law as the administration purports to do has always struck me as absolutely absurd. Article 1 of our Constitution creates a legislative process that today includes 536 different individuals. To assume the existence of a single intent among so many different minds, all with different interests, different purposes, different philosophies, and different methods, runs counter to basic logic, not to mention the theory of representative government at the foundation of our Constitution. This notion that we should be governed by easily manipulated arguments about Congress supposedly would have wanted long justified the hijacking of the law to undermine the clear meaning of the text. Fighting this abuse of the law and the Constitution has animated so much of my work over the past 38 years. And we have made enormous progress in reestablishing the bedrock principle that if we are governed not by vague claims about intent, but rather by the words themselves, words that have a fixed and discernible meaning with the power to bind us all, including the President. I will continue to fight for this principle as long as I have the honor to serve our people in this country. In this light, a proper reading of the detainee transfer and release notification requirements includes no such exception that the Obama administration imagines exists. We should always be skeptical of arguments assuming unwritten exceptions to laws, and here the relevant factors counsel strongly against assuming such an exception into existence. The statute uses strong, universally applicable language. Quote, the Secretary of Defense shall notify, unquote. Quote, each notification shall include, at a minimum, unquote. Quote, the Secretary of Defense may transfer only if, unquote, and the like. The text of the provision is particularly detailed. This detail, especially when read in conjunction with the numerous other incredibly detailed provisions in the National Defense Authorization Act and its many predecessors, many of which contain detailed exceptions, demonstrates that Congress is quite capable of creating exceptions to a provision like this one, but instead actively chose not to include one here. Finally, as has been clearly established, lawmakers were aware of the administration's desire to conduct exactly this sort of a transaction before the beginning of the legislative process. To assume such an exception when the Congress was aware of the administration's desire and proffered need for such a provision, but chose not to provide one, would completely undermine the notion that Congress has the power to choose its preferred policies by legislation. Put another way, how could Congress have been clearer that no detainee transfers could be accomplished outside its established process? And if Congress's bright line rule can be wished away by the Obama administration in this case, when can the Congress act to establish a policy to which the administration cannot carve out exceptions that destroy the very core of the law? In advancing this rather ridiculous attempt to misconstrue the transfer and release notification requirements, the Obama administration is simply avoiding making more controversial argument explicit. The administration's Pentagon General Counsel admitted as much last week. This argument centers on the president's contention that, quote, in certain circumstances, unquote, the transfer and release notification requirements, quote, would violate constitutional separation of powers principles, unquote. Other senior administration officials have made statements, albeit hesitantly, invoking the president's authority under the Constitution to disregard the statute. So though the administration attempts to cloak it in the complex obscurity of statutory construction, this is the real issue at hand. As a threshold matter, the rule of law and the separation of powers both depend on the long-standing notion that an unconstitutional statute is no law at all. And we should take the Obama administration's arguments about the constitutionality or the notification requirement as applied to the Taliban 5 trade very seriously. When appropriate, I have defended the president's authority to act in contravention of certain statutes. And I absolutely stand by the positions I've taken before, no matter how unpopular they have sometimes been. But I feel it incumbent upon me to lay out my case of why I'm so disturbed by the administration's actions here, not to deflect any charge of hypocrisy for personal benefit, but because I care so passionately about checking the Obama administration's overreach in this and so many other cases. To risk having these arguments dismissed without serious consideration of their merits would be unbearable. So I feel compelled to lay out my case in some detail. Here, the Obama administration's arguments fail on the administration's own terms, and in so doing demonstrates some disturbing trends at work within this administration. Now, the Obama administration has not advanced the notion that the transfer and release notification requirements are always unconstitutional. Instead, the administration has been very careful to suggest that the notification requirements unconstitutionally encumbered the executive branch because of the specific circumstance at issue in the Taliban 5 trade. And the general terms of the Obama administration's rationale initially seemed potentially reasonable, that it feared Sergeant Bergdahl would be endangered unless the administration moved quickly or swiftly and secretly to make the trade in compliance with the notification requirement would have prevented the president from exercising his lawful authority to order the detainee swap. However, the logic of the administration's rationale falls apart under closer inspection of these two key factors that it has cited as creating the special circumstances that justify disregarding the statute, the need for swiftness, and the need for secrecy. First, the need for swift action. The Obama administration has at various times suggested that Sergeant Bergdahl's health was in rapid and accelerating decline to the point of necessitating immediate rescue, and that the Taliban would refuse to agree to Bergdahl's release unless the administration executed the trade quickly. After examining what evidence the administration has provided us, a number of my colleagues from both sides and from both parties, including the senior senator from California, the chair of the Senate Select Committee on Intelligence, have expressed significant doubt about these claims. But even if we accept the Obama administration's claims that there existed a need for swift action, that when faced with this realization, compliance with the 30-day notification requirement would have endangered the potential for recovering Sergeant Bergdahl, and that these are the sort of circumstances where the Constitution authorizes the executive branch to act in defiance of a notification requirement, even if we accept everything the administration suggests, their argument doesn't totally nullify the administration's obligations under the statutory notification requirement. Under the administration's own logic, that the notification requirement is not unconstitutional per se, but rather only under certain circumstances, the executive branch still has a duty to take care that the laws be faithfully executed. Thus, even if it is authorized to order a transfer or release of detainees in less than the 30 days mandated by the statute, the President remains obligated to comply as substantially and faithfully as possible, mitigating any anticipated breach by keeping Congress abreast of negotiations and complying with the notification requirements as soon as any transfer decision is made or undertaken. But that clearly is not the case here. Instead, we know from the statements of senior administration officials that the administration deliberately withheld notification from Congress until after the trade occurred, months after negotiations to make this trade resumed and intensified, weeks after the detainee transfer agreement with Qatar was signed, and days after the final decision was taken. Given that the administration accepts the constitutionality of the legality of the notification requirement generally, its actions represent a direct effort to undermine the obvious core purpose of the law, giving Congress the opportunity to raise its objections and lobby against an ill-advised release or transfer before it happens. Mr. President, this isn't maximally faithful compliance. This is outright flouting of the statute. The administration, though, has also claimed a need for secrecy, specifically that informing Congress would endanger the prospects for Sergeant Bergdahl's safe return. I take this concern for secrecy extraordinarily seriously, and I know every one of my colleagues does as well. Preserving secrecy as not to endanger ongoing operations remains an absolutely vital cornerstone of congressional oversight of national security issues. And my long service on the Intelligence Committee engendered in me a particular appreciation for how necessary it is. But administrations have for decades briefed Congress on extraordinarily sensitive matters. Take the bin Laden raid. It's hard to think of an operation more sensitive than that. In both the Taliban-5 swap and the bin Laden operation, the mission objectives as well as the safety of our troops would have both been completely unattainable if details had leaked. Yet even before the bin Laden operation, the administration kept Congress appropriately and regularly briefed as required by law, which is to me testament to the extraordinary resiliency of our oversight structure. Mr. President, even those of us who have long defended robust executive powers in the national security context have long asserted that, quote, the constitutional basis for withholding notification can only be invoked credibly by its own terms. In very rare circumstances, a generalized fear that Congress might leak would not by itself suffice because the same fear could be invoked equally for all secret operations, unquote. In the case at hand, the Obama administration accepts the constitutionality of congressional notification requirements in most circumstances. It has also failed to articulate any particular reason why notifying Congress would pose a particular problem when compared to other sensitive operations, but the implication that it did not notify Congress just because of a generalized fear of leaks not only disregards decades of successful congressional oversight of intelligence collection and covert operations, but also makes an exceedingly radical argument that would give the President essentially arbitrary power to ignore what he acknowledges is a valid law. In this case, though, the administration's actions wholly undermine the notion that there was an unusual secrecy concern at issue here. First, consider that the administration itself estimated that between 80 and 90 executive branch officials were told of the decision to release the Taliban-5 ahead of time. In an administration that leaks sensitive national security information like a sieve, but zero members of Congress were informed. The Secretary of Defense and his General Counsel even admitted that Justice Department lawyers were told of the upcoming trade for the very purpose of keeping even a few key members of Congress in the dark. In light of the statutory requirement to notify just a key handful of members of Congress, this situation appears flatly absurd and certainly inconsistent with maximally faithful compliance with the statute. But furthermore, the administration had already discussed with Congress the potential for such a deal. They ran into bipartisan opposition, as expressed in the bipartisan letter of early 2012 signed by the top Democrat and top Republican on both the House and Senate Intelligence Committees. In response to that letter, media reports indicate that then Secretary of State and former Senator from New York promised that the administration would pursue further congressional consultations before making the exchange. And in 2013, the White House press secretary responded to a question about trading Sergeant Bergdahl for Taliban detainees in stark terms, promising, quote, "We would not make any decisions about transfer of any detainees without consulting Congress," unquote. So, Mr. President, why the more than 2 years of radio silence from the Obama administration? Why the disregard of a federal statute when the administration's arguments for doing so in this case are so disturbingly unconvincing? Why wait until after the decision could not be challenged before telling Congress? After reviewing these events, the answer seems obvious. President Obama and his subordinates illegitimately chose not to inform Congress until after the decision was irrevocable because they knew that Congress would object. 2 administration officials told Bloomberg News as much that, quote, "the failure to notify key members of Congress in advance was a deliberate move to skirt opposition to releasing the 5 Taliban prisoners," unquote. Now, the vigor of the Obama administration's defense of the deal has shocked many. It has not shocked me. To this president, this deal represents the apex of responsible winding down of the conflict in Afghanistan, not only in returning Sergeant Bergdahl, but also in releasing the Taliban 5, whom the administration has eagerly sought to release so often before. Just take it from the majority leader, who said he was, quote, "glad to get rid of these 5 people," unquote. And for a president and an administration that have demonstrated endless reservoirs of faith in the goodwill of hostile forces abroad, there is also surely hope, no matter how ridiculous, that giving into the Taliban's demands will somehow inspire renewed interest on the part of the Taliban in peace talks, as if that did anything but demonstrate how the Taliban's current tactics will get them concessions from the Obama administration. President Obama has on many occasions enunciated very clear beliefs of our detention operations at Guantanamo, articulating a nearly religious conviction that detention of Taliban, Al-Qaeda, and associated forces under the law of armed conflict is a beacon of this nation's evils to the world. And though the administration has faced immense political pressure to reconsider from many of us, I have absolutely no doubt that President Obama intends on following through with his long-time, recently repeated promise to make every effort to close Guantanamo during his remaining time in office. Many of my colleagues and I share a diametrically opposed view from the president's, one that is more focused on securing the stability of the Afghan government that our men and women in uniform have fought so hard to establish. But in our honest disagreement, President Obama sees only reflexive intransigence. On Guantanamo and on so many other matters, President Obama has proven himself unable to accept good faith differences with those of us elected to a coordinate and co-equal branch of government. This frustration has motivated the president to enact his agenda unilaterally. And in doing so, he not only poisons the well of congressional oversight of sensitive national security matters, as troubling as that is, but also by arrogating power with casual disregard for the structural restraints of the Constitution, he stretches our longstanding laws and norms past the breaking point. Mr. President, my allegiance to constitutional government and the rule of law compels me to stand up to this overreach by President Obama and the executive branch. I will continue to speak out against what I strongly believe are serious instances of overreach by this administration, as I have already on immigration sentencing, education, Benghazi, and of course, Obamacare. I urge all of my colleagues to join me, for what's at stake is not just our rightful authority to get done what our constituents sent us here to do, but also the very precepts at the core of our Constitution. That's why I've joined my colleague, the junior senator from Ohio, to co-sponsor a resolution declaring that the Obama administration violated the statute and calling for an investigation into the matter. Mr. President, with all that's at stake, registering our objections in this way could not be more important. Additionally, in light of these troubling events, which also involve the Justice Department, which should hold the separation of powers in the highest regard, I should note that I found myself now unable to support the nomination of Peter Kadzik to be Assistant Attorney General for Legislative Affairs. My deference to the administration's choice of appointees can only go so far, and I could not support a nominee who has so persistently refused to share the department's memos on the release of the Taliban 5. Absent a real commitment from Mr. Kadzik and the Justice Department to respect Congress's role under the Constitution, I felt compelled to oppose his nomination. Mr. President, on their own terms, the Obama administration violated the law by releasing the Taliban 5, dangerous men who are sure to return to the fight. In doing so, he not only endangered the lives of our men and women in uniform, but also jeopardized everything they fought and died for in Afghanistan. My commitment is to them and to the Constitution's division of powers and authorities amongst the coordinate and co-equal branches of government which they fight to protect. These loyalties would compel me to stand up to the Obama administration. And I urge all of my colleagues, regardless of party, to join me in this fight. Too much is at stake to let petty partisan concerns and blind political loyalty to the president take precedence over the weighty matters of national security and constitutional authority that are here at stake. And especially when one considers how much this branch of government is being ignored on almost a daily basis by this out-of-control White House. Mr. President, Democrats and Republicans have got to put a stop to this and have got to start standing up on these issues, or we're in danger of losing the Constitution itself. Mr. President, I yield the floor.